Good evening, friends. Today I intend to speak on Bharatiya Nagrik Suraksha Samhita 2023, its key provisions and changes vis-a-vis CrPC. Though nothing new I am going to state except I am trying to give a comparative analysis in my own humble way. The Bharatiya Nagrik Suraksha Samhita 2023, after referred to as BNSS, it replaced the Criminal Procedure Code 1973 CrPC and came into force on July 1, 2024. And it seeks to what? Objectives are to ensure speedy justice, bring transparency and accountability in investigation, make criminal justice system more victim centric. Now, what are the salient features of BNSS? A. Specific timelines for investigation and trial. BNSS prescribes specific timelines for different aspects of investigation and trial in order to ensure speedy justice. 2. Audio video recording of search. BNSS prescribes specific timelines for different aspects of investigation and trial in order to ensure speedy justice. Third point, important, attachment at property during investigation. The property of criminals which is deemed to be proceeds of crime can be attached by the court, and such proceeds of crime shall be distributed among the victims. This would not only create greater deterrence for crime, but would also provide some pecuniary relief to the victims of crime. Last point, in absentia trial of proclaimed offender. BNSS provides for in absentia trial of proclaimed offenders. Now, the major changes brought by BNSS with respect to investigative process vis-a-vis CrPC are as follows. Now, changes with respect to FIR section 173 BNSS. Registration of FIR irrespective of jurisdiction section 173 clause 1 BNSS. Now, FIR can be registered at any police station irrespective of the area where the offence is committed. FIR through electronic means section 173 1 2 BNSS. FIR can be registered through electronic means EFIR. However, the same has to be signed by the informant within 3 days. Conditions for conducting preliminary inquiry, section 173 clause 3 BNSS. In offences punishable with imprisonment between 3 to 7 years, the officer in charge of the police station may, with the permission of DSP, conduct preliminary inquiry to ascertain whether there is any prima facie case or proceeding in the matter. Now, such preliminary inquiry must be completed in 14 days. Now, interestingly, there was no such provision under CrPC. Now, forwarding daily diary reports to magistrate once in 14 days, it is enumerated under section 174 BNSS. Officer in charge shall forward the diary reports of information regarding non-cognizable offences once in 14 days to the magistrate. Interestingly, there was no specific timeline for this under CrPC. Now let us see what are the changes with respect to recording of statements. Section 176, 179 to 183 BNSS. Recording of rape victim statement at her residence, section 176 BNSS, it states, in relation to the offence of rape, the recording of the statement of victim shall be conducted at the residence of victim or at the place of her choice by a women police officer in the presence of a parent or guardian or near relative or social worker of the locality. Such a statement must also be recorded specifically it has been stated, may also be recorded by audio, video, electronic means, including mobile phones. CrPC did not have any provision for recording the statement of victim of sexual assault through mobile phone. Women police officer to record the statement of victim of sexual assault under section 180 BNSS. The statement of a woman against whom sexual assault is alleged to have been committed or attempted shall be recorded by a women police officer or any women officer. Such statements may also be recorded by audio, video, electronic means. Recording of statement of victim of sexual assault by female judicial magistrate. It is mentioned under section 183 BNSS. Section 183 clause 6A mandates that the statement of the victim of the rape shall be recorded only by a women judicial magistrate and in her absence by a male judicial magistrate in the presence of a woman. Section 183 section 6A mandates that the statement of the victim of the rape shall be recorded only by a women judicial magistrate. Now, what does the section 179 BNSS states? It states no male person under 15 years or above 16 of age, women persons above 60 or with acute illness not bound to attend police station, section 179 BNSS states. The other interesting factor is recording of statement by judicial magistrate witness in offences punishable with imprisonment for 10 years or more under section 183 clause 6 BNSS. In case relating to the offences punishable with imprisonment of for 10 years of life or death, the judicial magistrate shall record the statement of the witness brought before him by the police officer. And the CrPC did not have any provision like this. If the person making the statement is temporarily or permanently mentally or physically disabled, the statement made by the person with the assistance of an interpreter or a special educator shall be recorded through audio, video, electronic means, preferably by a mobile phone. Now let us come to the issue of arrest. Section 35 BNSS. It states like this: no arrest of aged or infirm person without permission or vis-vis in offences punishable with less than 3 years imprisonment, section 35 BNSS states. And in case of offences punishable with less than 3 years of imprisonment, no arrest of a person who is infirm or above 16 years of age shall be made without the prior permission or vis-vis. Now, use of handcuffs allowed in certain cases, section 43 clause 3 BNSS state like this: the use of handcuffs on the accused is permitted in the following cases: in case of habitual or repeat offender, or in case of person who has escaped from custody, or in case of organized crime, terrorist attack or act, drug-related crime, illegal possession of arms and ammunition, murder, rape, acid attack, counterfeiting of coins and currency notes, human trafficking, sexual offences against children, or offences against the state. Now, the medical examination matter is being discussed under section 51, 253, 184 BNSS. Application for the medical examination by any police officer, section 51 and 52 BNSS states, any police officer can move an application for the medical examination of accused. Under CrPC, only 51 could have such an application. Medical report of victim in rape cases to be given in 7 days. Section 184 BNSS states, and the medical officer shall, within a period of 7 days, forward the medical legal report, which is called as MLR, to the investigating officer, who shall forward it to the magistrate with police report. Medical examination report of accused to be given without delay. Section 52 BNSS. The medical officer shall, without any delay, forward the medical legal report to the investigating officer. Now, the issue of remand is very important. A very progressive section has been added under Section 187, Clause 2 of BNSS. Police remand can be sought even after the initial 15 days. Remand of accused can be sought under BNSS within first 40 days of arrest in cases where the offence is punishable with less than 10 years imprisonment. Within first 60 days of arrest in cases where the offence is punishable for more than 10 years imprisonment. It is interesting to point out that under CrPC, the police remand of accused could be sought only during the initial 15 days after arrest. So this is a little change, basic, significant change in the concept of remand. Now, changes with respect to search. Section 103, 105, 185, 186 of BNSS. BNSS has introduced major changes regarding the search proceedings as compared to CrPC. It has mandated audio-video recording of the entire process of search, and the following procedure has to be followed while conducting search. Action before proceeding for search in person and deputing subordinate police officer for search. Recording of reasons for search in case diary. The officer in charge of police station or IO is required to record the grounds of his belief for conducting search and also record the reason for not conducting search in person in the case diary. Section 185, Clause 1 BNSS. Now, conducting search in person, the officer in charge of police station or IO shall, if practicable, conduct the search in person. Section 185, Clause 2 BNSS. Now, what is the procedure during search? Recording of search and seizure through audio video electronic means. Section 105 and proviso to Section 185 Clause 2 BNSS. The officer in charge of police station or IO shall record the whole process of search by any audio video electronic means, preferably by mobile phone. Search to be conducted in the presence of two independent witnesses. Section 103 Clause 4 BNSS. And as per Section 103 Clause 4 of BNSS, before making search, police officer is required to call upon two or more independent and respectable inhabitants of the locality in which the police to be searched is situated. Refusal to become witness for search amounts to an offence under Section 103 Clause 8 of BNSS. Now, what is the action after search? Audio video recording of search now to be sent to the DM, SGM or JMC. Section 105 BNSS states like this. The police officer shall without delay forward audio video recording to the SDM, SGM or JMC, and it will send the record regarding search to magistrate within 48 hours. Section 185 Clause 5 BNSS states. And the IO also shall send the copies of the following record within 48 hours to the competent magistrate. Reasons for conducting search, reason for not conducting search in person, and deputing subordinate police officer in case someone else is deputed by IO to conduct search, and the details of search proceedings. Now, attachment, forfeiture or restoration of property in deeds under Section 107 BNSS. Application by O for attachment property made from criminal activity, section 107. The BNSS states that investigating officer may, with the approval of civilian of police or commissioner of police, make an application before the competent magistrate for the attachment property made from criminal activity or from the commission of any offence. After this, the very another important aspect is inquest report. It is discussed under section 194 to 196 BNSS. Inquest report to be sent to SGM within 24 hours. Section 194 clause 1 BNSS states like this. The inquest report shall be signed by officer in charge IO, and other persons shall be forwarded to the DM or SGM by police within 24 hours. Interestingly, CrPC did not have any specific timeline for this. Power to summon person for the purpose of inquest. Section 195 BNSS states. And for the purpose of inquest proceedings, no male person under the age of 15 years or above the age of 60 years, or a woman or mentally or physically disabled person or a person with acute illness shall be required to attend at any place other than the place where such person resides. If such person is willing to attend the police station, he may be permitted to do so. Now, what are the victim-centric provisions? Section 193 BNSS. Very interesting features are IO to inform the victim about the progress of investigation within 90 days. Section 193 clause 3 2 of BNSS states. The police officer shall within a period of 90 days inform the progress of the investigation by any means, including through electronic communication, to the informant or the victim. Second, victim-centric provision is further investigation to be completed within 90 days, it said under section 193 clause 9 BNSS. And further investigation during the trial may be conducted with the permission of the court trying this case, and the same shall be completed within a period of 90 days, which may be extended with the permission of the court. Importantly, victim to be heard before withdrawal from prosecution. Section 360 BNSS states, no court shall allow withdrawal from prosecution without giving an opportunity of hearing to the victim. Now, very important here, it is the issue procedure in case of complaint case against public servant and others. It is dealt under section 175 BNSS. Magistrate's power in complaint against public servant, section 175 clause 4 BNSS. The magistrate may take cognizance of a complaint against a public servant regarding his official duties after receiving a report from senior officers of such officer about the fact and circumstances of the incident and consideration of assertions made by such public servant. The issue of speedy trial is being discussed under section 175 BNSS. Tried in absentia or proclaimed offender under section 356 BNSS. The BNSS has introduced provision for conducting trial in absentia or proclaimed offender. Now, this allows the trial and pronouncement of judgment in the absence of the accused, which was not provided under CrPC. Section 356 of the BNSS mandates the court to proceed with the trial in absentia when a person declared as a proclaimed offender has absconded to evade trial and there is no immediate prospect of arresting him. It also specifies a mandatory waiting period of 90 days from the date of framing of the charges before commencing the trial. Under CrPC allowed evidence to be recorded in the absence of the accused under section 299, but did not provide for trial to be completed or for judgment to be pronounced against proclaimed offender. Now, this framing of charges. Now, framing of charges within 90 days under Section 263 BNSS. The magistrate shall frame the charges against the accused within a period of 60 days from the date of first hearing on charge. Another, judgment within a period of 45 days on completion of trial under Section 392 BNSS. Then after the termination of trial, the judgment shall be pronounced at subsequent time, but not later than 45 days. Judgment by session court within a period of 30 days. After arguments, extendable to 45 days under Section 258 BNSS. After hearing the arguments of prosecution and defense, session court shall give the verdict within a period of 30 days, extendable up to 45 days. Examination of witness by audio, video, electronic means under Section 265 BNSS. During trial, the statements of prosecution witness may be recorded by audio, video, electronic means. Prosecution sanction in 120 days. Provision is there under Section 218 BNSS. Under Section 218 BNSS, the central or the state government is required to decide request for sanction for prosecuting the public servant within 120 days. If the said government fails to do so, the sanction will be deemed to have been accorded by the government. Let us see the further key changes under the BNSS, which are important ones. Number 1. Forcenic aid in heinous crimes investigation. The issue is being settled under Section 176, Clause 3 BNSS. Section 176, Clause 3 of BNSS mandates the collection of forcenic evidence at the crime scene by a forcenic expert for offences punishable by imprisonment of 7 years or more. The provision is to be implemented within 5 years, during which such capacity is to be developed by the state government. And the state government shall also notify regarding utilization of forcenic facility of any other state until the state develops such facility. Compensation to persons groundlessly arrested. This is another very important key changes. We call it as malicious arrest under Section 360 of BNSS. Whenever any person causes a police officer to arrest another person, and if it appears to the magistrate by whom the case is heard that there was no sufficient ground for causing such arrest, the magistrate may award such compensation not exceeding 1,000 rupees to be paid by the person so causing the arrest to the person so arrested. Now, minimum SP rank officer to be Special Executive Magistrate under Section 15 of BNSS. In Police Commissioner area or Police Commissionerate area, minimum Superintendent of Police rank officer may be appointed as a Special Executive Magistrate. However, under CrPC, DYSP, ACP rank officer could be appointed as a Special Executive Magistrate. And service of summons through electronic communication is being stated as Section 64, Clause 2 of BNSS. Summons may also be served through electronic communication, a very important feature. The summons to produce document or other things, it will be discussed under Section 94 BNSS. Under Section 94 BNSS, any court or office in charge of police station can demand protection of electronic communication, including communication device which is likely to contain digital evidence. It is worthwhile to mention here that under CrPC did not have any provision for summoning the electronic record. SP can entrust investigation to DYSP under Section 175 Clause 1 BNSS, and the SP, Superintendent of Police, may, after considering the nature and gravity of the offence, require the Deputy Superintendent of Police to investigate the offence. Now, these are certain key features. Now, We, in a nutshell, very important factors which I would like to discuss is the timelines for various stages of trial under BNSS, and then it will be compared simultaneously with the CRPC at the same time. First stage is called the charge. Provision is this: framing of charges by magistrate for offences the magistrate is competent to try and punish. Under CRPC, no time was prescribed under Section 240, Clause 1 of CRPC. Whereas under BNSS, within 60 days from first hearing on charge, Section 63, Clause 1 BNSS states. Second, the charge procedure for an accused to file application for discharge in cases triable by Sessions Court. Under CRPC, no time was prescribed under Section 227 CRPC. However, under BNSS, it said within 60 days from committal, Section 250, Clause 1 BNSS states. Third, charge procedure for discharge by magistrate in case of absence of complainant on date fixed for hearing in a complaint case for offences that are non-cognizable and compoundable. No time frame has been prescribed under Section 249 of CRPC. However, under BNSS, granting 30 days opportunity to complainant to appear in court under Section 272 BNSS. Now let us talk about the plea bargaining. Procedure for application for plea bargaining by the accused in court where trial for said offences pending. Under CRPC, no time prescribed. Section 265B, Clause 1 CRPC states. However, under BNSS, within 30 days from the date of framing of charges, Section 290, Clause 1 BNSS states like this. Now let's come to the trial. Procedure for admission and denial of genuineness of documents by the defense and prosecution. No time has been prescribed under Section 294, Clause 1 of CRPC. However, under BNSS, soon after supply of documents and no later than 30 days, unless the court relaxes the time limit with written reasons, Section 330, Clause 1 BNSS states. Now, the trial in the case of the procedure for examination of the accused in custody through electronic means by magistrate or sessions court. There is no time prescribed under Section 281 CRPC. However, under BNSS, signature of accused to be taken within 72 hours of such examination under Section 316 BNSS states. Commencement of in absentia trial against proclaimed offenders by a court. Under CRPC, no time prescribed. Section 299 CRPC states like this. However, under BNSS, after a period of 90 days has lapsed from the framing of charges, Section 356, Clause 1 BNSS states. Now, the provision of issuance of 2 consecutive arrest warrants by court against proclaimed offenders before commencing in absentia trials. Under CRPC, no time has been prescribed. But under BNSS, execution of 2 consecutive arrest warrants should be within the interval of 30 days, states under Section 356, Clause 2(1) of BNSS. That in the case of trial, publication of notice to proclaimed offender to appear before court in a newspaper. No time limit has been prescribed under CRPC. Under BNSS, notice period of 30 days has to be given. Section 356, Clause 2 BNSS states. Now let us come on the issue of judgment and sentence. Pronouncement of judgment after examination of trial in any criminal court under CrPC states immediately after the termination of trial or at some subsequent time says under section 353(1) of CrPC. However, in BNSS, it says very clearly it should be not later than 45 days. Section 392, Clause 1 BNSS states. The judgment of acquittal or conviction by Court of Sessions under CrPC, no time prescribed. Section 235, Clause 1 CrPC. However, under BNSS, it says 30 days from the completion of arguments, extendable up to 45 days for reasons to be given in writing. It states under Section 258, Clause 1 BNSS. Uploading of judgment. A court to upload a digital copy of the judgment under CrPC, no time prescribed. Section 353(4) says. However, under BNSS, it says within 7 days from the pronouncement as far as practicable. Section 392, Clause 4 BNSS states. A disposal of property. Procedure for custody or disposal of property produced before a court or magistrate during investigation, inquiry, or trial. The court is bound to prepare a statement of property produced before it. Now, for this, no time has been prescribed under Section 451 of CrPC. However, under BNSS, within 14 days of protection of property before the court, it is stated under Section 497, Clause 2 of BNSS. Now, so if we see in this way, I have tried to give a little idea what are the changes that have been incorporated under BNSS. However, I have not given any latest case laws of High Court and Supreme Court on the various issues of arrest, remand, forfeiture of property, etc., which has been covered under the BNSS under the new rules and their interpretation. The idea is that if I would like to give the latest case laws on it, my video talk would have become very comprehensive. The purpose here was to give a comparative analysis of CrPC and BNSS, how in many cases and in many aspects, how the BNSS has given the time limit and time limitations of the different procedures of criminal jurisprudence. I hope my little humble effort may be of some help to the young advocates and may be appreciated for giving this kind of a analysis in a very short period. And I've deliberately tried not to touch those aspects which will give further explanation to the why it has been incorporated, why it has not been incorporated. However, the basic facts of CrPC and BNSS has been highlighted. Thank you very, very much. Thank you very much.